earlier, but quite frankly, we didn't have the funding at the time.
Sure.
It's an expensive process. So I'm asking the court to remove it from the trial calendar, schedule a status date. My understanding is the testing will take about 60 days or so to do. We also need to make some arrangements with law enforcement at the district attorney's office to get the samples to
That's right. As part of that, Frank's motion, let's see, the state moved to dismiss, I think it was count 5. There was a request on count 8. The court denied that, but count 8 is still the basis for this testing. Do you need a trial date to get that testing done within 60 days?
I don't. So it's not with the state crime lab, it's with a different lab.
All right.
So they don't have those same rules, policies.
Okay, then Attorney Lemkool states position for the record.
We're not opposing the defense request. We have to save our requests for when we need them. We don't need this done. So
All right.
We're not opposing it.
It's an unopposed motion. Court will grant the motion to adjourn the matters removed from the trial calendar to allow for that testing. And, so it's removed from March 11th, 2025. Now, well, let's take up the joinder motion. Or are you prepared to take up the joinder motion, Attorney Selleck?
I suppose I would object to joinder. I think these two cases are factually distinct. Certainly isn't the defendant. But one's in the context of a search warrant of a home, the other is a traffic stop. There's not really an overlap with witnesses in general. I suspect, at least for the newer file, there's potentially a citizen witness for the state. Other than that, it would be law enforcement. The older file, I'm not really sure. I don't have a witness listed in that case, so I'm not sure who the state's been calling. But just by virtue of another case being tried at the same time, that by itself is prejudicial to the defendant. The newer file is factually very simple. I don't think that that would be a one-day trial if both cases do end up trying for the jury. So I don't think we'd be wasting judicial resources by not joining these cases.
Attorney Lemkool, go ahead. Basis for the, is the state still asking for joinder and reason why?
We are, Your Honor. I disagree that they're not related. They involve the same drugs, similar parties. I think a couple of the parties, at least the gal in the car, also was a witness with the house. I think virtually there's no way the defense is going to be able to try these cases without opening the door. The minute Mr. Preisler takes the stand and says, I wouldn't have done that, I don't possess that drug, then it all comes in and they open the door anyway. So then it comes in. So I think it's just cleaner and safer and less of an appellate issue to start actually trying them together. They are intertwined. As I recall, Mr. Preisler got out on the $100,000 cash bond he posted, and then he was stopped in the car with the drugs up the private part of the female in the car, who gave a statement to police that Mr. Preisler asked her to put the meth in her vagina to hide it, and made the remark of, this will cost me $100,000. I mean, talk about being intertwined. It's involved with the other cases that he's on the bond for, this $100,000 cash he's posted, and now he's making the statement about costing $100,000. That is clearly panoramic evidence that's admissible, relating to a clear picture being given to the jury of what was going on with Mr. Preisler and his actions. I mean, all of these cases involve his possession of meth, his delivery of meth, and the state's alleging possession of materials to make meth. So all of these things were intertwined, Your Honor. It would really be an inappropriate use of resources for us to start having 3 trials on all these cases. Because if we have one, we're going to have trials on the other. So unless globally we can just try this stuff together and get it all dealt with. And again, virtually, I don't think I've really done a significant trial where if the defendant does take the stand, which I think in this case I'd be hard pressed to believe Mr. Preisler wouldn't, that the door isn't open. And it doesn't have to just be opened by his denial on the stand. It can be opened by the defense if they start arguing to the jury that his client would not have been in possession of materials to make meth. He wouldn't have been in possession of meth, although it was found in his bedroom in the house. He was delivering meth in the community in the other case, and then he is asking somebody to put meth in her vagina in the other case. So, Your Honor, they're all intertwined. They involve the same drug, close in proximity, all of the things you're to look at to make a determination whether this comes in. And again, the door is probably virtually by whatever defense Attorney Michalik brings in about his client not possessing meth, that these types of things are going to get brought in through the witnesses anyway under their defense. So at this time, we think it's just easier for all parties and the court to just try it all together.
Any other comment, Attorney Michalik?
No, Your Honor.
Well, my understanding is we're going to get a status date, and then at that point, you're going to know what your results are. Not the joiner motion isn't dependent upon what those results, but I'm just saying we're not going to schedule a trial until we have that status date. Or are we going to schedule a trial today?
I think maybe we should with how busy the court is with your, I don't know, I've been off on a leave. I don't know if you're still really busy with trials, but you're usually really busy with trials. And it does seem appropriate. And I'd like to also address that with meth.
Well, first of all, regarding the, if we get a trial date, if we're waiting on something, 60 days, right? That'll take us into May. We're probably going to have to schedule it in September because I don't know how many trials I'm going to have, if any, in July or August. And June, I can take a June, but we have some sexual assault cases that are old that'll probably bump most cases. So, Attorney Lemke, what about that if I say September?
Yeah, that's fine. That's fine.
Right. Attorney Michalik?
That's fine. Yeah, that's plenty of time.
I'm going to set a status date, and then I'll have a final decision on the on joinder. I think it's about a 19-page complaint on the original file, the 1216, and about 6 pages or so, I think, on the 1548. The court's to look at if they're similar in type and circumstances, are they part of a common scheme, same witnesses, and so on. So I was looking at both complaints. There are a slew of police officers in that first complaint, but the two that I read in the second complaint are different. But I want to check what Attorney Lemke said, that one of the lay witnesses is going to testify in both files. They're pretty close to proximity. The one file is in June and July, and then the second file was in August. I think the court is most likely going to join the matters, but I guess I want to just finish reviewing the bigger file. And for judicial economy and efficiency, the court also looks to say, would this second file be admissible as other acts? They probably would be. So I'm thinking that there is something to be said for joining them. At this point, Attorney Michalik, I really don't see that as really being prejudicial towards your client, but I want to make a full record, and so let's set a status date, and then I'll confirm the court's decision on the joinder at that time. You said about 60 days, so that would get us into May. How about that first week of June?
What's that for?
That status.
Okay.
Then we'll do a status, and then I'll set a trial date, okay? But the status, the date that I'm using right now is the 2nd. Attorney Michalek, come up with that date.
That should work.
Morning, all right?
Yes.
How about 9:30?
We do 9 or 9:15.
Sure. You can do 9:15. Okay, so 9:15 for a status. Both files will be called at that time. And we'll finalize the issue on joinder. And then as far as the trial date goes, June is pretty much filled up. Holiday in July, I think the best. Let me just look. And I've got a civil trial. Really? I'd probably the 23rd. Like 3 days, Attorney Lipton. Probably 3 days
What?
for trial.
I think 3 for sure.
Yeah, why, how about the 23rd?
I have a 4-day trial the week before. I guess I would prefer to have a little more time in between them if I can.
What's the date of this one, Your Honor?
I'm looking at September 23rd. First week is juvies. Next week, we have this 2-week civil trial. They all say is going to go. Then we have the 23rd. Attorney Michalek doesn't work for him. Then on the 30th, we're back in juvie. I got juveniles twice that month.
You don't have anything in August?
I don't. Let me just see. I've got juvies.
Could we use the first week of October or the second week?
Well, I could. I just don't know about the kids in August yet. I should know this. Well, I just found that there's a case that's opened up. A civil case is opened up now, so I could do it. I suspect. I don't know if I can do it the 19th. Attorney, I'm thinking that first week of October, Attorney Lemko.
Yeah, that's fine.
Yeah. There's nothing there. October 7th. Got the whole week. You could even start it on Monday if you want to do that. Attorney Lemko? Well, Monday or Tuesday?
Tuesday's fine, Your Honor.
All right, Tuesday, the 7th of October. It'll come sooner than you think. We've got our status, and we can do further scheduling if there are any other motions, or certainly for a final conference for that trial.
Well, again, I'd like to address a condition of bond, which I think can affect things too.
Sure. All right. Before you get to that, Attorney Michalek, anything else for today's record to address?
I don't think so.
And Attorney Lemko?
Yes. So I just called CGS, Laura Hetman. Your Honor, the court is not addressing the violation, or maybe it was addressed at the previous hearing that Mr. Preisler had allegedly on February 17th of 2025. This has become a chronic issue with Mr. Preisler that either A, he doesn't test he tests positive for drug use, or he bails on a request that he show up. So I talked to Mr. Michelik about it and indicated that I wasn't going to start filing bail jumping yet without finding out what was going on with everything or what it entailed. And what Mr. Michelik told me is that when he became aware of it, he immediately told his client, you got to come in. So I wanted the rest of the story. So I called Ms. Hetman and I said, what's the deal? Is Mr. Preisler in compliance? Was it non-compliance? She said, he missed a drug test on February 17th of 2025, did not respond to her. She verified she had left a message. His excuse was when the following day, Mr. Michelik, and he as an officer of the court, appropriately said to his client, look, you got to report, you got to respond to them. That he then did follow up with her, but as Ms. Hetman indicated, it's a little suspect when Mr. Preisler tells her, hey, look, I didn't know about it, I left my cell at the homeless shelter, but then when Mr. Michelik finds out about it, he has the ability to reach his client, and then his client calls CJS. And he then volunteers, oh, hey, he called her on the 18th and said, oh, hey, I can come in now. Well, like she indicated, that's not how it works, because they're not going to take drug tests of people when they're volunteering to come in, because she suspects that he knew he, at that point, would have a clean one. So what I guess where I'm going with this is the state is requesting that as a condition of bond with CJS, that in the event that Mr. Preisler is not following up with the random drug test, this is a bond violation, or it subjects him to bail jumping when he does this kind of stuff, that he be able to, a phone call can be made that he be taken into custody. This has happened repeatedly, Your Honor. This isn't the first time. This court is the one who lowered the bond and allowed him to post and get out. And now it's becoming almost babysitting for CJS, for law enforcement, for the state to keep finding out about Mr. Preisler not in compliance. And I'd indicate, Your Honor, you may recall the defense has been the one who's wanted to have a trial, wanted to do things. And now it's a little suspect that Mr. Preisler is out of custody, and now they want to do drug testing, and then Mr. Preisler remains out of custody. So it's very clear what's going on with respect to that, Your Honor, because now Mr. Preisler's out, so he's not interested in going back in. But also now, see, this just extends and elongates that CJS has to babysit what's going on here. The state gets phone calls from law enforcement every time he is not in compliance. And it's just becoming a cycle here. So we would like a condition of bond that in the event that Mr. Preisler does not cooperate, show up, and as Ms. Hetman said, and I agree with her view of this, Mr. Preisler tells her, oh, my phone was at the homeless shelter, so I couldn't get it. Yet, as she indicated, he certainly picks up his phone and had it on him when his attorney calls him. And then, again, Mr. Michelik's the one who's in compliance with everything. He appropriately tells his client, look, you better call them. You got to get in there. So, we don't have time. Mr. Michelik shouldn't have to be the one to have to deal with that as well, when we're all getting phone calls that, once again, Mr. Preisler's not in compliance. So we would like a condition that in the event that he is not in compliance with CJS, that they contact law enforcement and he's taken into custody for non-compliance.
Attorney Michelik, I'll let you respond, but what?
I could have done that. I could have issued a warrant.
No, do they need an order from the court? They can do that anyway, right? I mean,
well, true. I could have done this the last time. I actually wasn't on leave and wasn't aware this was all going on. And that is not compliance. As Ms. Hetman just said again, for her to get a phone call the day after by Mr. Preisler, which he did follow up on the 18th after, again, Mr. Michelik's the one in compliance telling him you better call, that at that point, like she indicated, they're not going to start doing a drug test when someone's saying to them, oh, I'll come in for a drug test, knowing 24 hours later then he could be clean. So it's just becoming troubleshooting again for all the outside agencies when these things are happening, Your Honor.
Any comment, Attorney Michelli?
Well, my only comment is what Ms. Lemkool is describing is not a bond condition. Bond condition would be something that Mr. Preisler would have to do or comply with. If they think there's information that warrants a warrant, that can be done in various different ways. As far as my client not having his cell phone on his person on a particular day, I think that's true. I was trying to get a hold of my client on that day. He didn't answer his phone. It went right to voicemail. His son had contacted me asking how to get a hold of him. But the next day, he did answer his phone and he had an explanation. He just didn't bring it with him. And you can't just go back into the homeless shelter and pick things up willy-nilly whenever it feels like it. They have special hours when you come in and go out. He took 2 drug tests that week. Both were clean. He is in compliance with the sobriety condition, which I think is the main thrust of the whole purpose of the bond that he come forward. So I don't think there's any reason to amend the bond at this point, Your Honor.
He's had 1 drug test since then. I don't know what he's telling his attorney right now, but I spoke to Miss Hetman, who conducts it. There's been 1 that has been clean since then. I absolutely disagree with the defense interpretation of a bond condition that you must be in compliance with CJS to say that that is not him violating. That is absolutely him violating it, because when he is told to come in for the random test, you got to do it that day at that request. So that is non-compliance.
Well, that's right. That's why I'm asking, what is the court, what are you asking the court to do? I mean, that's a condition of bond right now, it's CJS compliance, right?
Right, and that he's got to go in at the time. I mean, I don't know if you need to spell it out for Mr. Preisler, that compliance with CJS would be, these are the conditions they outline from, he's got to be in it. I can right now ask law enforcement to have him taken into custody and jailed and bring him up tomorrow and bail jumping. I'm not doing that. I'm just asking the court to make it clear, because Mr. Preisler continually violating this is not okay.
I will do that. Look at this. This happens a lot. We get this CJS condition and someone misses a drug test, or they're testing positive, or there's an ADL violation, and it's brought to the attention of the court, and the court says, don't do this again, and says, if you continue to do that, you can be picked up, you can be charged with bail jumping, you're violating your condition of bond. Now, here's what it says on this CJS report. It says specific conditions from both files: GPS to be installed, report to CJS with random drug testing, defendant to report to CJS within 24 hours of court or release from custody, defendant to have no possession of methamphetamine, defendant to have no contact with Stephanie Teagues, ADW, KLR, residence, place of employment, absolute sobriety, no contact with drug users or sellers. Court modified the bond because there was a lot of new information that mitigated some of the original charges, but these conditions of bond remained. And Mr. Preisler, you're under the microscope. Everybody's watching you. I mean, it's not that difficult to comply with CJS. We do the OWI treatment court here in Branch 6. You randomly have to go in for testing. You got to do it that day. You can't, if you violate that, you're in non-compliance. So it's quite simple. Comply with CJS. That's a condition of bond, not only in this case, in a lot of cases. And if they violate that, then the state has the ability to order someone to get picked up. They can file new charges. So it's very clear, just follow through with that bond condition. Now, I'll emphasize that because of the calendar. We put this, and I'm scheduling some other cases in September and October, but we did put this out a ways. It might seem it's going to come faster than you think, but there's many months now between that and October. You have to comply with your conditions of bond. That's not the court's decision. That's up to the state. If they hear that you're in violation, they can take action. So I think that's kind of what the court normally does. We're going to treat this like other cases. Mr. Preisler, you know what the conditions of bond are. And you obviously heard Attorney Lemkool. Follow all conditions, and that means timely drug testing. That's one of the reasons that CJS is requested in drug cases is because they can do that to make sure that people are clean, because people on drugs are worse flight risk. They're worse, my experience, to show up in court. So it's a reasonable condition. Just follow through, okay? So I think that's all that's all the court should say.
Yeah, and you do have the absolute sobriety as well, so that's no use of alcohol or drugs, marijuana, any illegal substances.
Right, if there's a positive test, you're violating your condition of bond.
Yep.
So, absolute sobriety, standard condition. Absolute sobriety, no contact with anybody who uses or sells any kind of drugs. And I should state this, and I do in other cases, that includes marijuana, because that's illegal in Wisconsin. So, any comment or any question, Attorney Michelik?
He's also supervised by a probation officer who is also testing him. So,
Right.
again, he's remained sober since his first violation report where he was charged.
Good. Well, the court will just assume that he'll be complying with his bond condition. Now, we have our status date, right? And we have a trial date. Attorney, anything else that we should be doing today?
No, Your Honor.
I suspect we'll be resolving both of those cases in October. So, but we can address that as well as, I think, we can address a number of motions at that next hearing. Because did you file a motion to eliminate, Attorney Michelik?
I did.
Yeah, we can address that too. The motions eliminating Attorney Lemkool were filed on the 20th. So you'll have time to prepare for that.
And what's that motion date, Your Honor?
We can take that up at that status date. Unless you want more time. Unless both of you want more time. It's kind of a standard motion eliminating.
Yeah, I think the only other additional one the state is filing is Mr. Preisler is on the internet teaching people how to make methamphetamine. I previously brought up at a different hearing, I think a year ago, that the state, I have not reviewed his videos about him making meth. I know he wrote the books on how to make meth, but these videos that are all over the internet, as well as perhaps his books, would be something we would moving for the mission of. Certainly, again, I'm putting the defense on notice that in the event Mr. Preisler would testify or the defense would open the door by alleging that he would not be someone that would make meth, be in possession of meth, the fact that he has written these books, the fact that he is allegedly on the internet. Again, I haven't seen it. I've heard about it. I'm going to have law enforcement basically memorialize it in a video we can submit to the court. I think the only way for you to make this decision, Your Honor, would be for you to view something like that. So,
Did you file a formal motion on that? I can't.
I don't know that we filed on his books or his videos. I previously had said it, we were in the record at one point last year, but no, I don't think we did. But just to be clear on the record, because we never remember this later, this is the first day I'm back after a 6-week leave. So I don't know what did or didn't get filed by any of my colleagues, and I don't think I asked any of them to do that. So I will also file that motion in the next month.
I don't recall that, but Attorney Mitchell, you're on notice, and again, on June 2nd, we can take up a number of issues then. All right, anything else, Attorney Lempool?
I think that's it.
Attorney Mitchell? All right, President Bond continues, matters concluded for today.
Thank you.
Yeah, we'll make it a motion.